Hello viewers, welcome back in our new video. In this video, we will discuss an important topic, and I'm sure this topic will be important for everyone. So guys, today's topic is ITC mismatch as per GSTR-3B and statement 2B not maintainable. So guys, as we all already know that ITC is an important topic in GST. ITC is adjusted with outside GST to reduce the burden of liability. In GST, for availing ITC, there are various conditions, and among them, one condition is that ITC in GSTR-3B should be matched with Statement 2B. Now, in this video, we will discuss if ITC in GSTR-3B is not matched with Statement 2B, how tenable in the eye of court this condition is. So, without wasting our time, let's start the video now.
Hello viewers and students of AITCS. Welcome back to the AITCS official channel. In this today's video session, we are going to discuss again one of the important topic which is very important for all the persons who are dealing GST matters. In this video session, we shall discuss whether mismatch of ITC as claimed in GSTR-3B with respect to GSTR-2A or 2B is maintainable in the eye of law or not. Many of us has came across with a situation while the GST authorities conduct audit or assessment proceedings, they deny all ITC claimed which are not matching with GSTR-2A or GSTR-2B which has already been claimed in GSTR-3B. Before going further, we shall know what is GSTR-3B, what is GSTR-2A and what is GSTR-2B in short. We know that GSTR-3B is a return which is the summary return which contains all the particulars of outward supplies, inward supplies, export, exempted sale, nil-rated sales. In this return, we have to claim input tax credit which we have availed from the purchase of taxable goods and services from the supplier. Input tax credit is adjusted with output GST which lowers the burden of the tax liability of the taxpayers. Again, we know that there are various conditions for availing input tax credit in section 16 of the CGST as well as state GST law. Various condition contains that the person who are availing input tax credit must have fiscal tax invoice, the person must have received the goods and services actually, etc. And one of the vital condition is notified in the GST law is that the input tax credit which has been claimed in GSTR-3B must be reflected in GSTR-2B. GSTR-2B is a statement which contains auto-populated data which has auto-populated with GSTR-1 filed by the supplier. If your supplier does not file GSTR-1, then that particulars of invoice does not reflect in GSTR-2A or GSTR-2B. GSTR-2A was considered earlier, but nowadays GSTR-2B is considered for the purpose of allowing of input tax credit. Whenever there is a mismatch of input tax credit which has been claimed in GSTR-3B but is not reflecting in GSTR-2B, the assessing authority, GST officers doesn't allow that input tax credit and the taxpayer has to reverse the ITC along with penal interest and penalties. Suppose that in the year 2018-19 you have claimed input tax credit of rupees 5 lakh which is not reflecting in GSTR-2B. In that situation, the assessing authority while conducting the audit or assessment proceeding shall not allow rupees 5 lakh as input tax credit. When they denies this input tax credit, it is automatically added back to your output GST and you have to reverse that ITC along with interest. So rupees 5 lakhs becomes rupees 10 lakh, and this is very painful aspect of the GST law. In this video session, we shall discuss, is there any remedy with respect to this problem, because many of us have availed ITC and while conducting the audit by GST authority, it is found that the amount is not matching with GSTR-2B. Is it really that the assessing authority is denying and it is tenable in law or not? In this video session, we shall discuss this problem with respect to a case law which Honorable Calcutta High Court decided in favor of the taxpayer. So, if you go by the pure act or bare act of the GST law, then we shall find that a taxpayer is not eligible to get input tax credit of that amount which is not reflected in GSTR-2B. So, if your ITC is not reflected in GSTR-2B, you are not able to avail that input tax credit. But if you approach to the Calcutta High Court or if you approach to any jurisdictional high court of your state, then there is a chance to get the relief, because in the recent judgment delivered in the matter of Loknath Industries versus State of West Bengal, the Calcutta High Court has ruled that the assessing authority, the GST authority, should first penalize the supplier before penalizing the taxpayer, because it is the duty of the supplier to file GSTR-1 if the purchaser fulfills all the remaining conditions which has been prescribed under section 16 of the CGST as well as State GST Act. Then the burden of proving shifts to the supplier of the goods and services. Here the High Court has went and advised the tax authority that you should penalize the supplier who fails to discharge his duties, who has not filed the GSTR-1. Because of the error, because of the mistake, because of the ignorance by the supplier, the purchaser of the goods and services cannot be penalized. So any person who have denied input tax credit in any assessment proceeding or any audit proceeding can, while replying to the GST authority, cite the case law of the Honorable Calcutta High Court. If the authority does not consider that aspect of the ruling of the High Court, then contempt petition may be filed against that authority. Once again, I would like to summarize the provision of this act. First, you should note that if your input tax credit claimed in GSTR-3B is not reflecting in GSTR-2B, then as per the law, you are not eligible for the input tax credit. But if the mistake has already been happened in past years, suppose from the financial year 2017-18 to till now, and assessment proceeding or audit proceeding is going on, in that proceeding if you have came across a situation where your ITC claim is not matching with GSTR-2B, then in this case also you have to get the relief. If the amount of input tax credit along with penal interest is big, then it is advisable to approach your judicial high court. The High Court may consider the matter on the merit. If it is found that you have written to your supplier through email or various communication channels to file the GSTR-1 and you can prove that it is not on your part of mistake, you are proactive while advising to your supplier to file GSTR-1, then the court may decide the case in your favor. In the recent judgment which we are discussing in this video, that is Loknath Industries, where Calcutta High Court has gone ahead to deliver the judgment in favor of the taxpayer. While finalizing the judgment, the Calcutta High Court also advised the GST authority to take proper action against the supplier before initiating any penal action with respect to the taxpayer. So students, hope that you have understood the topic. If anyone has any confusion, then he may ask or he may suggestion in the description box. Further, if anyone wants to take e-filing GST TDS training with us, please write for the prospectus and the WhatsApp number given in the description box. Thanks for watching.